Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss a very important case on section 148. The case has been decided by Bombay High Court and the name of the case is HALITE Personal Care India Private Limited versus Deputy Commissioner of Income Tax. This case has been reported in 448 ITR at page number 303 and the judgment came on 13th January 2022. In this particular case, the assessment of assessee was completed under section 143 subsection 3 and a deduction was allowed to the assessee after giving a detailed cautionary under section 142 subsection 1, and the assessee has also replied extensively on that section 142 subsection 1 notice. But after 4 years, the department issued notice under section 148 by giving reasons that the assessee has not truly and fully disclosed all the material facts which were necessary for claiming that deduction, and the assessee raised the objections against these reasons, and the assessing officer disposed of these objections mechanically. And in that disposal of the objections of the assessee, the assessing officer said that the High Court order on the amalgamation of the assessee was irregular. He has gone to that extent. The effective date of the amalgamation of the assessee was 1st March 2012, but the date of the order in which the amalgamation was effected was 18th April 2012, but the amalgamation was effective from 1st March 2012. So this is a very common practice that in amalgamation the order came later but the effective date is earlier. But the assessing officer was saying that the amalgamation date is 18th April 2012 and the AO has gone to that extent by saying that the order of the High Court of the amalgamation is irregular. So in this particular case, the High Court quashed the notice under section 148 by saying that the reasons of the assessing officer does not disclose that which material facts were not disclosed by the assessee which were necessary for making the assessment. This is the prime condition. In the absence of these allegations, that particular allegation, if the assessing officer is simply saying that the assessee has not disclosed truly and fully all the material facts which were necessary for assessment, that was not the end of the reasons. The assessing officer has to tell that what actually assessee has not disclosed to the assessing officer in the original assessment. So the allegation should be specific. That is the requirement of the proviso to section 147. Because you are going to open a concluded assessment in the garb of reassessment, you cannot change your opinion. Change of opinion is not allowed. It is not the case where the loan transactions are accepted in the original assessment under section 143 subsection 3 and after that the information comes from the investigation wing that these loan entries are bogus. So in those cases, generally we have seen that the courts are very reluctant to give or to quash the notices under section 148 because in that case the new information comes to the knowledge of the assessing officer. But in this case, no new information was on the file of the assessing officer on the basis of the same records. Now the assessing officer wants to change his opinion on the deduction which was claimed by the assessee. So we have seen in the recent past that the Bombay High Court is very strict in all those cases in which the department wants to reopen the assessment under section 148 beyond 4 years and where the assessment of the assessee has already been completed under section 143 subsection 3. The department has to be very cautious. The reason should be specific. It should not be mere change of opinion. There should be new information on the file of the assessing officer. The same set of information cannot be relied upon for issuing the notice under section 148. So in this particular case, the department quashed the notice from the scratch and no remand back. So this is the real justice in according to me, where the notices are quashed, not remanded back. So once again I am repeating the name of the case. The name of the case is HALITE Personal Care India Private Limited versus Deputy Commissioner of Income Tax and others. Thank you friends.